Namaste. Good morning. Welcome all to the American Telugu Association ARTA webinar on immigration. Thanks for joining. So we do have a special guest and well-known speaker, attorney, to present this webinar, and we do have Bhargavi Garu as a moderator. So to facilitate others to join, my name is Ramkrishna Reddy, Joint Secretary, American Telugu Association. So just I want to briefly give about ARTA so that gives time to others to join. So American Telugu Association is a national level non-profit organization which is established 31 years back. So the main vision of ARTA non-profit organization is to pass on our culture to the next generation, conduct community services activities, charity events. So we are doing for the last 31 years within US as well as back in India. So as you know, we are conducting so many community services. For example, like trainings in IT, and time to time, based on the current topics, conducting webinars on immigration like this, what we are doing today, and charity events both in US and India. Also, every 2 years, we do, to promote our cultural other activities, we do conferences every alternate 2 years. So this year, we are doing in Washington, DC. It's the 17th conference and youth conventions. It's happening on July 1st, 2nd, 3rd in Washington, DC. It's going to be a very big convention. We are expecting around 10 to 50,000 guests from all over the world. So that's a good opportunity. I request everybody go to americanteluguassociation.org and find more information about ARTA, convention, and other information. So as I said, community activities, we are doing like a emergency team. We do have emergency team. So as emergency team, will provide all the help what Telugu and Indian community time to time they're facing within USA. For example, any parents, visiting parents, something happened to them, if they need emergency visa or passport to go to US. For example, last 2 years, it was a very bad situation. People stuck up in US going in emergency situation back to India. So we did help on behalf of ARTA working with the Indian Embassy. So also students, we are providing scholarships. Every year we are providing 12 scholarship, $1,000 each on behalf of ARTA for the college going students. And any people on emergency accidents happens and students sometimes need some help with financially difficulties. So those kind of emergencies help we are doing on behalf of ARTA. And also charity events. We did conduct a lot of charity events both in USA and India several years. In particular, last year, we faced COVID situation across the world. And last year, when Delta variant happened in India, there is a shortage of oxygen. So on behalf of ARTA, we sent 500 oxygen concentrators, masks, or even some vaccinations also we did provide freely. And to give back to India, we did conducted a lot of school projects. For example, in both Telangana and Andhra Pradesh states, we did provided several schools, digital classrooms, mineral water plants, dual benches, and whatever the school supply that school needed, and building some infrastructure also, like a kitchen rooms or game rooms, whatever, libraries like that. So here in USA, we are doing a lot of cultural activities. For example, International Women's Day, which comes every year in the month of March. So last 10 years, we are doing International Women's Day to engage and empower women's community. So this year we are doing on March 8th. It's a virtual event. You are going to get details soon. So please try to watch that International Women's Day event. And again, ATA is doing a lot of work, charity, it's a non-profit organization. So to give opportunity to many community people to become an ATA member, currently we reduced to $50 per person per family to become a life membership. So I would suggest or encourage to go to americanteluguassociation.org and become ATA member today and avail all the benefits, free trainings, and other benefits. Like we do have some benefits, discounts in several uh, restaurants, all the stuff back in India also. So please avail and help and promote ATA to serve better. So with that introduction, I would like to pass on to start a webinar on immigration to Bhargavi Garu. Before that, just please watch a video on 17th ATA conference. Thank you so much.
లెగరా మనకాహ్వానమంటోంది ఆట వదరా మన తెలుగోడి ఐక్యాన్ని చాట వాషింగ్టన్ డీసీ వీధులు పోటెత్తాలిరా లోకం తెలుగోడి ఖ్యాతిని జై కొట్టాలిరా లెగరా మనకాహ్వానమంటోంది ఆట మన తెలుగోడి ఐక్యాన్ని చాట వాషింగ్టన్ డీసీ వీధులు పోటెత్తాలిరా లోకం తెలుగోడి ఖ్యాతిని జై కొట్టాలిరా కష్టాలు వచ్చినా కన్నీళ్లు వచ్చినా భుజాలు తట్టనేస్తమే సభలకు వచ్చిన వితరణనిచ్చిన ఆ మాతృమట్టి కోసమే 90లోనే బీజం వేసి చెట్టైంది ఇవ్వాలిరా ఎన్నారైనా చిట్టెట్లలో పెట్టింది దీపాలిగా తెలుగు సంస్కృతికే అన్నై హోరెత్తిందిరా వాషింగ్టన్ డీసీ వీధులు పోటెత్తాలిరా లోకం తెలుగోడి ఖ్యాతిని జై కొట్టాలిరా
ఆకాశమే అక్కై అలరించే ఈ వేదిక ప్రతివారికి ఆహ్వానమంతమే రండిక
కళల వైభవం యువత ప్రాభవం ఆట మహోత్సవం జరాలి అందరం చూడాలి సుందరం రెండేళ్ల కోసం భరం విచ్చేసిన తారాలోకం వినోద విన్యాసాలు వచ్చేసిన ప్రతిభకు ఇచ్చే సన్మాన ప్రోత్సాహాలు తెలుగు ఐక్యతకి ఆట చేసే వ్రతం చూడ పలికింది నీకు సుస్వాగతం వాషింగ్టన్ డీసీ వీధులు పోటెత్తాలిరా లోకం తెలుగోడి ఖ్యాతిని జై కొట్టాలిరా
Hi everyone, good morning. Welcome to webinar on immigration.
Today, we are going to discuss on various immigration topics like interfiling, immigration updates with our guest. Friends, if you have any immigration related questions to ask our attorney, you can comment on YouTube Live or Facebook Live too. I will ask those questions. Today, I would like to introduce our special guest, Thomas V. Allen, the founder and principal attorney of the Law of Thomas V. Allen. His office is one of the leading law firms in immigration in the United States, with 2 different offices in New Jersey and another office in Irving, Texas. They have 10 attorneys and more than 50 paralegals. Thomas has been recognized as one of the top most 10 immigrant attorneys in the United States. Their firm is known for handling all the toughest cases successfully. They have a high success rate in the industry. They also challenge USCIS delays and denials by filing various litigations throughout the United States. He is here with us today to give us more information on immigration-related issues. So without any further delay, let us dive into the topic. So hi, Thomas, how are you doing? Welcome to the webinar.
Good morning, everyone. Thank you, Atta, for having me. And keep up all the good work, bringing knowledge to the community and also all the various functions that you do. Now, keep up all the good work. And thanks for having me today.
It's our pleasure. So Thomas, let's start today's webinar with the H1b Cap registration. So what is the information required for registration process or any documents required, or what is the fee for CAP registration process? Can you elaborate on these things?
Yes, we'll initially talk about the whole process itself. In 2020, the USCIS changed the whole process. Initially, you file all the petitions, and out of which they do the lottery and they select the cases. And that's how the process was done. But to improve the efficiency of the system, to avoid all these paperwork and all the wastage of money, USCIS came up with a new process. So now what is done is you just give the basic information of the employer will give the basic information of the candidates that they want to file through the lottery, and the USCIS will do the selection, and out of those, the selected ones, you file the H1b petition. So last year, around 365,000 registrations happened. There is only 65,000 H1b visas that can be issued in a year. But this year, we are anticipating anywhere between 500,000 to 600,000 registrations to happen. So coming back to the question, what documents you have to give for the registration? Nothing. It's basic information like the name, date of birth, place of origin, country of origin, passport number, basic information. That is required for the registration, and you pay a fee of $10. So this year we are anticipating a huge filing, and what's the reason? One of the reasons for this kind of a filing happening is because of the multiple filings. Many employees or beneficiaries, to increase their chance of getting into the lottery, they file through multiple companies. So that's called the multiple filing. So these numbers which we are seeing, 500 to 600,000, it is overly inflated numbers. So the question comes up, is it legal to file through multiple companies? Is it legal to increase the chances? Is it legal to file through different companies? So coming to that, with the existing laws and regulations, the USCIS cannot stop multiple filing, because the rule says that a person cannot file, one company cannot file 2 petitions for the same beneficiary, or 2 related companies cannot file H1s for the same beneficiary, but different companies can file a petition for the same beneficiary. So unless the USCIS or the Congress changes the rule, these multiple filings will happen, and we will see more numbers happening. Another reason why there is a lot of filings is this year we are seeing that there's a lot of H1b petitions filed from outside the country. During the last administration, it was really, there were a lot of denials, and the administration was very strict. But now we are seeing that there is a easiness in filing, getting it approved. So there are a lot of numbers that are being filed from outside the country too. And on top of that, there is a supply and demand issue here also. There is a shortage of at least 3 to 4 million IT professionals that are required in this country. And the available number is only 65,000 H1Bs that can be issued in a year. So, so the government has to increase the number, unless otherwise, you will see such a huge number of filings this year. So
Yeah.
that's some introduction about the CAP and what's happening this year.
I got it. I have a question. So like in last 2 years, kind of due to pandemic and something, due to this pandemic, it have a larger impact, right? So many people did not like to come to, are not interested to come to US in the past few years. And there has been 2-3 lotteries taken, I think in 2022 or something, 2-3 times they have taken lotteries. So people are so scared to travel to other countries. So this year, is there any thing like that going to happen, or everyone will come to US?
So the main reason why last few years there were less people coming from outside was due to the travel ban.
Exactly.
Because of this COVID, there was a travel ban for the non-immigrants to come to this country. But with the new administration, that has been lifted. If you're vaccinated, you can freely travel to US.
Oh,
so
great.
This year we will see more people traveling, and again, consulates have opened up. There are a lot of visas being issued. So obviously we will see a lot of people coming to this country this year.
That's really good. So once the name is registered, can they withdraw the registration if they don't like and they want to withdraw it? Is there an option to withdraw it?
So there is a timeline factor into this. So the registration is open from March 1st to March 18th. So during this period, if March 1st to March 18th, if someone files a petition for these beneficiaries and they want to withdraw, it's possible before March 18th. And after 18th, it's not possible. So yes, until March 18th, it's possible to withdraw.
It's possible. Okay. So if one person is registered and he don't want to proceed with H1B filing with the same employer, what can he do?
So after March 18th, if the employee is selected and he doesn't want to proceed, there is no withdrawal process in there. One thing is just let it go. So, the withdrawal is only, as I said, is only before the 18th.
So they cannot do that after March.
They cannot do anything after that. Yes.
Oh, okay, okay. So what if the beneficiary loses the project before filing the petition?
Okay, so now coming to the timeline, once it's selected, usually the USCIS will come back and say on March 31st whether you have been selected or not. So from April 1st till you have 90 days to file the H1B petition. So that is till the end of June. So if you lose a project before that, and you have 90 days, meanwhile, if your employer is able to find a project for you, they can still file the H1B. And if there is no work availability in that 90 days, unfortunately, they will not be able to file it.
Oh, okay. So when can they start filing H1B?
From April 1st to June 30th.
June 30th. Got it.
So they have 90 days to file the H1.
Okay. So can you tell us about CAP, GAP, and elaborate on that?
Okay, so CAP is a remedy, that's an automatic authorization that is given by USCIS if the students who has an OPT EAD, if his OPT is expiring after the filing of the H1, it's an automatic authorization of work till October 1st or September 30th. So the student can work until September 30th, and beyond that, he can stay in the country, but he cannot work. So this period is the CAP gap. So that automatic authorization is called the CAP gap and H1B. Now, to avail the CAP gap, there should be a change of status that you have requested on while you file for the H1b petition. So there are two options. You can either file for a change of status from F1 to H1, or you can ask for a consular processing. Means once you get the H1b approved, you are willing to go out, get the stamping, and come back. So it should be applied as a change of status.
Yeah. So Thomas, right now we have some questions from our YouTube viewers. So can we go ahead with that?
Yeah, please.
First question from Harish Kumar. He's asking, how can we file adjustment of status and labor petition simultaneously?
So there is no option to file 485 along with labor certification. So there are three steps, right? The labor certification, then it comes the I-140, and then 485. So once the first step is clear, the labor certification, then what if the I-140, at the time of filing the I-140, if the priority date is current, then you can file 485 along with the second step, but not with the labor certification.
Got it. So next question from Suresh Reddy Garu. My question is, can we file and submit the H1b documents for two companies or consultancies for same candidate? A scenario in lottery, two files are picked from two different companies.
So this is what we discussed initially, multiple filings. There are an employee is filing through two different companies. So the law restricts only filing through a related company. Now, question comes, what's a related company? So if there is a common ownership, obviously it's a related company. But USCIS has expanded the scope in 2017. And what they said was, if the owners are related, still it will be treated as a related company. Even if there is a similarity in both the filings, they will see that it's a related company. But this I'm not talking about the registration. This is the second step when you file the H1. So if two companies file H1 on the same project, same client, they will still see it as a related company. And another thing is, even some cases we have seen, if both the companies use the same attorney and the petition looked almost similar, that they would treat them as the related companies. So there are various ways how USCIS would look for a similarity in both the petitions. But now coming a step back, if at the time of registration, if both the companies are selected, USCIS in the current registration mechanism, there is no way they are capturing an information where they could see what's the client location they are filing, work location, job title, all those. So as a result, people are filing through multiple companies. And if they are getting selected through multiple companies, they are deciding which one to go with out of all this.
So if it's a different company, there is a possibility to have multiple options, right? They can.
Yes, with the existing regulations, it is possible to do that.
Possible. Oh, okay. Got it. So there is one more question from Harish Kumar. To elaborate the question, I have I-140 approved from my previous employer and current employer is yet to file my labor. So is there a way we can file labor and AOS simultaneously?
No. So he has to get the labor certified. And when at the time of the I-140 filing, the company will request to port the priority date from the other I-140 to this one. So that's one, and then the priority date most probably would be current for him. If it is, then he'll be filing 485 along with that I-140 request.
Got it. So there is one more question from Ravi Kumar Sai Kamgaru. If someone chooses visa waiver option mistakenly, even though he is not eligible, what is the impact on visa approval?
So even if he selects for a visa waiver, now the US Department of State expanded the scope of visa waiver. So anybody who had a previous visa, it need not be an H1. If they had an F1 or a B1, they are eligible, and that could be very old too, but they are eligible to apply under the visa waiver program or the Dropbox. But if you are not eligible and by mistake they gave a visa waiver program under the Dropbox, most probably when they go there to drop the documents, they are going to see that he is not eligible and will give a interview date and ask him to attend the interview. So in short, it's not going to get rejected or not having any negative impact. Obviously, they will ask him to go through the consulate.
Okay, thank you. And there is one more question from Sai Supreme. My visa max out date will be next year, Feb. My employer started PWD this month. If my perm is not approved by Feb, what is the other options to continue to stay in the US?
So, unfortunately, the whole labor process, perm process, is very much delayed. So the first step of the perm to get the prevailing wage certified, which we used to get it in less than a month. Now it's taking 8 to 9 months. And from there is a 1 month ad placing time, 30 days. You have to place all the ads in the newspapers and other things. Then 30 days waiting period, and from there 6 months. So you're looking like 14 to 16 months to actually get the labor certified. So now if it is in September that he is going to expire, he has a problem, because if the employer has not started this early, he may not be able to get the I-140 approved within that period. Now, if he has things to pack and leave, and he needs more time for that, there is an option to file for a B1, B2 change of status. So within 6 months, for 6 months they can continue staying here until that is approved. But while that B1, B2 is pending, he may not be able to file another change of status from the once the I-140 is approved, because it becomes a bridge petition. The B1, B2 is not approved. It takes like 8 months to get the B1, B2 approved. So changing the status again back to H1 might be a problem staying in the country. So at some point he might have to leave the country. Maybe it's for to get a stamping on H1B.
Thank you. And there is one more question from Vignam Vishal. How is part-time jobs in this situation?
I'm assuming he wants to change a full-time job to a part-time, or if that is possible, he has to file an H1B amendment, making the full-time, change it to a part-time. If he's asking if he wants to take a second job along with that, if it's with the same employer, he still have to file an amendment of the H1, show both the projects. If he's doing that part-time job with another employer, then that is called a concurrent H1. He has to file an H1B concurrent H1 part-time through the other employer. Hope I covered all the different areas.
Yes. Really great. And most spoken topic in these days is interfiling. So many questions on interfiling I received recently. So do you suggest EB to interfile to EB2? Because I have a situation where recently we downgraded to EB3 because it moved fast, and we got our EAD approved, and then progressed and it moved back again. So we are very confused we should interfile to EB2 or we can stay in the EB3. We are not sure. Can you elaborate on this?
Yeah. So a little history about it. There is something that changed very recently. We all know that. So USCIS came up with a new announcement few weeks back saying that there is an exceptionally high number of employment-based visas available for this fiscal year. So last year, Department of Labor announced that there is 290,000 employment-based visas, green card available. Usually it's 144,000 every year. But due to this COVID, a lot of family-based visas were not issued, travel ban, many people were not able to avail it. So there was a spillover, we know that there is, so because of that, there is more than usual numbers, which is like 290,000. But what USCIS did is they did not move the priority date. We were all hoping that last October 2021, they would move the priority date like 2020 October, and people will get green cards. But what happened in October 2020 was USCIS moved the priority dates drastically, but they were not able to handle the huge volume of 485s they received. And they still haven't come out of that backlog. So what they decided this year or the last fiscal year, they will move the priority date gradually. So USCIS and DOL came out last few weeks back and said there are a lot of more EB1 and EB2 visas available than the pending 485. And they asked or suggested everyone, if you are eligible under the EB2, file it under the EB2, not EB3. Now we all know that in October 2020 there were a lot of downgrades from EB2 to EB3, and EB3 has been oversubscribed. So USCIS also suggested that if you have a EB2 I-140, interfile the EB3 with the EB2. This is first time in the history USCIS came and suggested something like that. So after that, in the last a month, everybody wants to interfile from EB3 to EB2. Now, and also USCIS came up with a new process to interfile. Previously, USCIS had no set guidelines how to interfile. So what we used to send an interfiling request to USCIS. Nothing happens. After 1 month, we call back again. We send the letter. We do this exercise a couple of times. After a few months, maybe we call them and we get a confirmation. Okay, it has been done. So it's just over a phone call. There is no mail, nothing which shows that the interfiling has been done. But now what USCIS has done, it changed its policy manual, and it said what are the process involved in interfiling, what documents are required, and where to file it. So USCIS, what they are now saying is that the interfiling must be in writing. Obviously, that was the same process before. Also, you have to send a letter to them. And they said you must include the I-485 Supplement J form. So this 485J was used previously for porting from one company to another. So 485J has two parts to that. One is the bona fide job offer confirmation, and another is the request to job portability. So this form is signed by the employee and the employer. Both of them has to sign it. And now, if the I-140 is approved, you have to, EB2 I-140 is approved, then you have to file 485J along with the interfiling request to a California location, which they have given. You send this request to there, and what happens is that you get a receipt notice for the 485J. And eventually down the road, within a month or so, the USCIS issues an approval notice for the 485J. So this is a confirmation that the interfiling has been done. Now comes to the second part of the question. Now, you have a EB2 and a EB3 pending. Both the priority dates are current. Well, what should you do, right? So should I interfile to EB2 or not?
Not correct.
So that's a $1 million question, but I would say it's more of a personal choice. What happens is right now, if you are going to interfile it from EB3 to EB2, a lot of people are doing it. Now, who are filed the downgrade, everybody is moving the ship from EB3 to EB2 because USCIS suggested it. Again, that's going to get backlogged at the same time. So when you put the interfiling request, there is a delay. You're not going to get the green card immediately. The USCIS has to call for the EB2 file, which is, if it's long approved, it has gone to a warehouse of USCIS. Now USCIS has to call back that file. They have to verify all these things. So that process takes some time. If both are current, you might be better off staying with the EB3 because it might get approved. So it's more of a personal choice. Another option you have is, if you want, you may file another 485 along with the EB2. What we have seen is, the downgrade time, everybody filed with the Texas Service Center, and they are very much backlogged. No, they have not even approved the EADs and advanced parole, which was filed in October 2020. So, if you are filing just the 485 alone, most probably you will be filing with a different service center. And what we are seeing is, there is not even a biometrics. They are capturing it from the other 485. And things are moving very faster in that case. And some people have already got 485s approved in few months. So you have an option. Now, there's a question. Can you have two 485 pending? The
Exactly.
answer is yes and no. So
No.
if you cannot have two 485 spending for the same I-140. That is no. But the rule says that one immigrant petition, means one I-140, can have only one 485, which means you can have multiple I-140s and multiple 485s. So there is a EB3, EB2 I-140 which has a 485, EB3 also. Now USCIS at one point when they are adjudicating it, let's say EB2 they are adjudicating it, and 485 is there also. So they will come and say, hey, you have two 485 pending. Which one do you want to proceed? And at that point, we make the choice. Okay, we want to proceed with the EB2, or they have given a query as to which one to proceed, and they approve it. So yes, that is possible.
Okay. So I have one more question now. So we interfiled from EB3 to EB2, and the process is going on, and suddenly the EB3 starts moving forward faster. So can we come back again to EB3, or is that allowed or no?
You can interfile back again. That process again takes time right now. So that's what I was telling. If it is possible to do to multiple 485s, you don't have to do that switch over back and forth.
Okay, so they can be active on both at the same time.
Exactly.
Oh.
You are in a better position filing to 485s. Obviously, there's a lot of money involved. You're spending, the Uscis fee is very high with all the costs involved. Yes, but you have a better chance.
Got it. Thank you so much. And we have some more questions. Suresh Reddy garu messaged us, if the candidate present status is L1B and it is going to expire in July 22, if the H1b is picked, what is the process involved in change the status and when he can travel to India for stamping?
So the earliest that we can ask, the earliest start date of employment that we can ask on the H1 is October 1st. So if you are filing a change of status from L1, which is expiring in June or July, USCIS will look on October 1st, do you have a non-immigrant status? You don't. So they will not approve this as a change of status from L1B to H1 because there is a gap. Now, during that gap, because of that gap, you can either file it as a consular processing, or you can file a B1, B2 if you want to continue staying here and do some other activities. Yes, but again, this we discussed in one of the other questions. It becomes a question of bridge filing because now there is a pending B1, B2, and on a pending petition, you are filing another change of status to H1B. USCIS may not approve it with the I-94. You still have to go out, get the stamping. And you can go any day for stamping, but you can enter only 10 days prior to the H1B start date.
Got it. Thank you. And Suresh Reddy garu is asking, what is the latest process of Dropbox for L1B to H1B candidates?
So Dropbox is same like before. You answer certain questions. Now there is some eligibility questions that they are asking at the time of your filling up your DS forms and taking an appointment. So if they ask, have you previously been issued a visa? Yes. Have you ever previously been denied a visa? No. So when you answer these questions, if you are eligible, the system is automatically telling hey, you are eligible for a Dropbox. And that's how the visa process is going on.
Okay. So for the Dropbox option, the procedure is the person should be with the same employer to process through Dropbox, or they can shift to another employer also that will be applicable.
Yeah, they can. Like I said, they need to have any other visa which was issued in their home country and nothing more. So, so with the employer, whoever is through whom they're applying, he is eligible for a Dropbox if he has a prior visa. It need not be within a time frame. It can be an F1 which was issued 10 years ago. He's still eligible. That's a
So there
possibility.
are no conditions for that, right?
No, conditions are there. He should not have a visa rejected, and the first visa should have been issued in their home country, and he is applying for a Dropbox in his home country. So there are certain conditions, but not that the prior visa should be from the same employer. These were all prior conditions. Initially they had for a Dropbox, one of the eligibility was it should be with the same employer within 2 years. Then they expanded it to 4 years, and then they said it need not be from the same employer. It can be from H1b prior visa stemming from any employer. But now they have expanded that scope and said, it may be any visa, or H1b prior visa could be from any other employer, which is okay.
Okay, so after stamping, if they change to any other employer also, that's fine, no problem.
No, so visa need not be with the same employer. It can be with a different employer. It's just it gives an option to enter the country. So he can come and join a different company, start the payroll, as long as he has a valid H1 with that employer.
Got it. Thank you. And there is one more question from Smart Family. My priority date is November 27, EB2. I recently changed my job, and my new employer saying they will be filing my I-140 after an year or so. Will that be fine, or will there be any issues?
I mean, see, it's the employer decision when to file it, right? So if they decide they will file it after a year, that's it. But here, what we should think is, is he eligible for a AC21 porting to this company? If he is eligible, he can port that. Means if 180 days has passed after he filed the 485, he can always port that to his new employer if he wants. So he has an option for that. But again, like the specific question that he is asking, if they are filing after 1 year, is it okay? It's still okay, because at that when the new employer files the I-140, he will be porting the priority date from his old I-140 to this one. So if that is current at that point after 2 years or 1 year, he can still continue the 485 through that.
Okay, thank you. And there is one more question from UV. I have approved I-140 in EB2 with H1B. Plan to go to India for a year to come back on L1A visa. Once I apply as multinational manager, if L1A is rejected, can I come back using the existing EB2 I-140?
I mean, yeah. So let me rephrase that. He is coming here on an L1A or a EB1C, and it gets rejected, and he is going back, and he can come back not on the I-140, but on the H1B. If he wants to come back, he can come back. If he has a 485 pending on the I-140, obviously he can come back on that. That is not an issue. Otherwise, he should have a non-immigrant status to come back here, which most probably could be the H1B. So just because the EB1 got denied, it's not going to impact the other one.
Okay, thank you. And there is next question from UV. How difficult to prove in visa interview to extend H1B?
I mean, that's one good thing was, until last month, it was very difficult to get appointments. So after they came up with this Dropbox for everyone, they have added 22,000 Dropbox slots availability, which means now everybody is getting interview dates, and most of them are getting in the month of March and April. And what Uscis is doing is now they have liberalized the whole process. So it's easier to get the visa stamped compared to the last year. There are very few 221Gs issued. There are Delhi Consulate, still we see a lot of 221Gs issued for a client letter, but I would suggest compared to last year, it's way less. So I would say it's much easier to get a visa now compared to the previous years.
Okay. Thank you. And there is one more question from Sai Supreme. If perm is in process, if I keep my visa active, like going to India, before the visa max out, after perm approval, can I come back?
So what I would suggest in such situation is don't max out the complete 6 years, leave some days in there. And once that perm is pending for 1 year, or if perm is approved, that I-140 is approved, then what the employer can do is they can recapture that remaining period in that 6 months, plus they can add 3 years or 1 year based on the approval of the I-140 or the perm. If perm is pending for more than 365 days, he is eligible for 1 year H1b extension. If the I-140 is approved, he is eligible for 3 years. So yes, he can come back along with the recapturing of whatever remaining period in that 6 years, he can come back.
Got it. Thank you. And coming back to interfiling. So is there any time, this many times we can do interfiling, this many times only allowed to do interfiling like that, or we can do how many times we want?
You can do multiple times. There is no limit that you can do. But it, as what USCIS in their policy manual says, interfiling can be done only between these 3 employment-based categories: EB1, EB2, EB3. But as many, there's no limit they have to.
There is no limit. That's good. So can we send the medicals along with the interfiling request?
I would say no. The reason is we are filing this interfiling request to a new location, which is in California. It's not a service center. So if you send this to California, we believe that it's not going to go into the file, which is with a different service center. So this California location is just facilitating the interfiling, and they are not adjudicating your petition. Your petition will still be with the service center.
Okay. So if there is any RFE on our I-1485, does it affect interfiling or something? We should do anything for that?
Not necessarily. Now, what we suggest in such situation is go ahead and respond to the RFE. And once that is responded and online, it shows that the status has been updated as RFE response received, then go ahead and do the interfiling. So there's not much clarity on where the files would move to a different location or not. But it's for the best interest, it is always good to respond to the RFE and then file the interfiling request.
Interfiling, got it. So once interfiled, can we change employers?
So what happens is once you do the interfiling and USCIS has received it, you have to wait 180 days. It's the same rule as if filing a new 485. You have to wait 180 days before you can do ASC 21 porting, right? So same rule applies again for this. Once the interfiling is done, you have to wait 180 days before you can change the employer and before you can port it to another employer.
Got it. So should I file interfiling separately for principal applicant and spouses and other dependents separately?
Not necessary. You don't have to. When you're putting the interfiling request, the return request, we always include all the beneficiaries, the spouse and dependents in there. So one interfiling request is enough for everyone.
Okay. So now so many people are interfiling back to EB2. Will there be retrogress in EB2 also after some days, kind of?
It's what it looks like, because in October 2020, when everybody filed this downgrade, when the EB3 moves, it was most of the filings were downgrade from EB2 to EB3. They were eligible for EB2 and EB3 at that point, right? So now, especially with the USCIS announcement that came out, go ahead and file with EB2, everybody in our office, we did a huge filing of downgrades. all of them, almost everyone wants to do it to a EB2. So obviously, this is going to overload EB2 and take the burden off of EB3. But there's a 290,000 visas available. Many people could be lucky, could get it under EB2, but some would still get into the whole 9 yards and pending.
So in next few months, is there a possibility to move EB3 faster than this, or it will stay in the same place?
No, this fiscal year, we don't even expect. So after October, there could be some shift. The Department of State has to reassess how many EB3s have moved to EB2. It's going to take some time. So maybe not until this October. So we might see some changes after October.
Got it. Thank you. And we see that many EADs and advance paroles filed in October 2020. It's still pending. So is there any options to expedite those things?
And unfortunately, there are a lot of EADs that are pending even from October 2020, like you said. The USCIS is very much backlogged on that. We hope they just give the green card instead of EADs. That's
exactly.
much easier because it's been pending for a very long time. I mean, there are a couple of steps people can do to get the EADs and advanced parole approved. One is, though it's a failed system, you can still call the USCIS and ask them to expedite it. Give them a reason. If you have to travel out for some reason, or if you're losing the job or whatever it is, tell them. Sometimes it works because it's been pending for a very long time. And another thing is just contact your congressman, or the senator. I've seen sometimes it works. Second is, if there's an emergency, somebody is, your close family relative is sick or something back in India or anywhere, you can call USCIS and request an InfoPass appointment. So earlier, what we could just go online and just take an appointment, go to and visit the local field office. But now they took out that option, and now you have to call USCIS and they will give the appointment. So go there, take the advanced parole form I-131, and they might approve
the documents.
Yeah, and they might approve it. But only thing is, it should be a life and death situation of a close relative. So if you say that my uncle is going through some surgery, they're not going to approve it. So it should be a life and death situation of a close relative. Another option is to file a litigation. Our office files a lot of litigations. If your EAD is pending for like 6 months or more, you have a high chance of getting it approved. So litigation actually works.
So if people reaches your office for this, so can you help them out to file a litigation?
Yes, we can. So one of the interesting factor is there was one employee for whom we filed, client for whom we filed the litigation, and it got approved like in it's like in 2 or 3 weeks after filing that.
Wow.
It was very fast. The US attorney called us and said, yeah, we are just approving this. We are not filing the response to this. And they just approved it. And she went and posted some saying that I got approved in like few weeks, and some Facebook group or something. We ended up like filing hundreds of litigations, and we had very high success rate on that. So it works actually, litigation.
Wow, that's nice, right? So now people got one option to use this, so they can get it approved as soon as possible, and it will not affect their employment.
Most of the time, the US attorney, they don't want to fight it. It's a huge task for them. And a lot of time they have to waste on this. And the judges, they don't like to waste time on this kind of thing because there's a huge delay. But you have to present a good case when you're litigating it. Your mortgages, how families dependent on the income, the threat of losing the job, all this you include it. The judge, we just get the approval immediately.
So USCIS will not fight it.
Most of the, unless their policies is that you are filing a litigation before 6 months.
Oh, okay.
Filing for more than 6 months, it's much easier to get it approved.
Got it. Nice. Thank you. And there is one more question from UV. If I want to apply for L1A visa, if I have approved the H1b petition, do I need to cancel before applying L1A petition?
No, you don't have to. These are all dual intent visas, H1 and L1. Having multiple, it's okay. So you can apply if you have a approved H1B. If you have a visa stamped on H1 and you go for a stamping for L1, usually they cancel it without prejudice. So they put a stamp saying cancel without prejudice.
Okay, thank you. And there is one more question from Srinivas Renukunta. I am currently in Canada after my H1B got rejected in 2018. We are planning to go to US in next 6 months. Can we file EAD in US and come back to Canada?
So, I mean, one thing that is not clear is they on what status they are coming back here. I'm assuming they are coming here and on some H1B or something, and they are going to file the 485 and then go back on the EAD. Yes, it is possible. They can go back, but not permanently stay here and just come back occasionally to renew the EAD and advanced parole. That's not going to happen. They have to have a job in the US, but traveling back and forth is possible.
Got it. So there is one more question from Suresh Reddy. Once the H1B picked, and is there a chance to expedite the process to get approval faster? And how soon we can get the approval using this process?
So if it is the cap H1Bs, unless USCIS comes back and say that we are not going to accept a premium processing, there is an option to expedite it in 15 days. You can get the H1B approved, or you can get an RFE within the 15 days. The filing fee is $2,500, and there is an option. But last year, they did give this option of filing premium processing for all the cap ones. 2 years back, they used to stop it because they couldn't handle so much of volume, but now there is a 30-day filing window, right? So they are not getting that many cases on once. So the premium processing is there, in short.
Okay, nice. So let's go back to the interfiling. We had a lot of discussion on interfiling, and coming to the H4 EAD. What is the current processing time for H4 EADs and how to expedite it?
Yeah, so we all know that USCIS came up with a settlement or a memo saying that there is an automatic extension of EADs for H4s and L2s and E3 non-immigrants. But in reality, it did not help. It came out of a settlement of a lawsuit between USCIS. So there were hundreds of people who had filed this lawsuit to expedite the H4 EADs. And then the judge was asking, what is this happening? It's been pending for a year, 2 years, and H4 EAD is not approved. And before any decision came, the USCIS settled it with the plaintiffs. But they didn't get a good bargain on this settlement. So what the rules say, or the settlement says, is that if you have an H1B extension that is timely filed, means before the expiry of the H4 EAD, if you file for the H4 EAD extension, then the H4s can work up to 180 days from the expiry of the prior H4 EAD. But there is a string attached to that. You cannot work up to 180 days if you don't have a validity of the I-94, H4 I-94. So if H4 I-94 is valid only for, let's say, 1 week, you can work only for 1 week and not 180 days. So it did not really help. But it will help if they are ready, if the H4 applicant wants to leave the country, go out, get a stamping and come back, then they get an extended I-94 and they can continue working. But if they are already here, it's not going to work. So yeah, it helps some people, but not everyone. L2s at the same time, their employment authorization is incidental to their status. Means if they have an L2, status, they are authorized to work. They don't have to even apply for a EAD, but if they want, if they can, but it's optional. And the USCIS said they will make working with CBP, they will make some changes to that so that the I-94 will show that they are eligible to work, because L2s are the same visa given for the children too. So now the I-94 will say L2S for the spouses, which means they are authorized to work. And USCIS is asking people to go out of the country, come back and get a L2 endorsement from the CBP so that they can work. But we are hearing that a couple of our clients have called the CBP and they updated the I-94 with the L2S endorsement. So again, so there are some changes to that. For H4 EADs, the processing time is almost, and I did not change much. Even now, 8-10 months is still pending for many people, unfortunately. Now, the same process what we told before, you can call the USCIS, contact your local senator and congressman, they might approve it. Again, the litigation option is also there. One good thing is with the healthcare professionals, they said, if you are working as a healthcare professional, call USCIS and they will give a priority, because they don't have people working in the hospitals. There is a shortage of staff. But otherwise, there is no clear-cut guidance on this. People are still suffering on H4 EADs, not getting it approved. I would suggest fight it, file a litigation in court, file a mandamus lawsuit to expedite it. And that's one of the options to get it approved.
Nice. So you said there is an auto extension for 6 months after the expiry, right? So is this applicable? Is this in effect right now?
It is, but again, the caveat to that, the catch is that 180 days or the validity of the H4 I-94.
Got it. So in my case, what happened was my H4 EAD is getting expired and I have been waiting for 1 year, and USCIS didn't reply anything. They are keeping me waiting. And then my H4 EAD expired, and next day my EAD got green card EAD got approved. So for people in this kind of situation, what can they do to safeguard their job or secure their job?
You're one of those lucky ones who didn't have a breakup job. But this is really bad for many people, because some people, they have their health insurance through the spouse who is on H4 working through H4 EAD. They run the risk of losing that. And nowadays, with one person's income, they're not able to sustain the lifestyle. They need the additional income from the spouse. They have mortgages, they have car payments, a lot of things, insurance payment. Losing a job because the USCIS delay, that's the last thing that should happen in this country. Unfortunately, that's what's happening right now. And that's where, when you're telling a judge all these things, there is no way they're going to tolerate this. They're asking. So that's where the US attorneys, they don't even want to take this to a judge. When we file this case and give the summons, next day they're calling us and saying, hey, we are going to approve it. We are not going to file an answer to this. So yes, the best way, you can contact your local senators, congressmen, but USCIS is saying they're short of staff. They have their own issues, but unfortunately, it's taking a toll on many families, unfortunately. But we can still fight it and get it approved.
That's great. So we can file a litigation and we can get it processed.
Yes.
That's nice. So can you tell us about visa stamping, and is there any waiver program for the interview about that and all? Can you elaborate?
Yeah, this is what we discussed a little before. Yes, one major change what has happened is, because after this travel ban, many people were stuck outside. Now, USC, they have a very the Department of State or the consulate, they are short-staffed. So USCIS came up with this option of expanding the visa waiver, interview waiver program, or the Dropbox. So for countries that are involved in visa waiver program, like some European countries, Canada, all those places, people of citizens of those countries, they don't even have to have a prior visa stamp. They can even first time stamping, they're getting a Dropbox and they can come. But countries like in India, their only option is if they have a visa issued from India, their home country, then they don't have to go through another interview process. They are waiving that interview process. Then you just once you're filling up the application, it will tell you whether your interview is waived. Then you're eligible for Dropbox. Then things have become easier, and they have increased the number, and they are giving visas to everyone so that they can ease off the burden that the system has with all these people who are stuck in India going for interview at the same time. And now many people from US is also going for a visa because for the last two years, they have not able to travel, see their dear ones. So they're also traveling to their home country. So, I mean, this visa waiver program is actually, interview waiver program is actually helping everyone.
Helping so many people. That's good. And before we wrap up, there are two more questions.
Sure.
Srinivas Renukuntla is asking, can we start consular processing for I-485 from Canada? I am working with the same company who filed my I-140.
Yes, you can. So if the I-140, there's an option. Do you want to adjust your status in this country? And if you said no, then once the I-140 is approved and the priority date is current, what the USCIS will do is they will send it to the national visa sender. From there, you will get a notification saying, okay, pay this fees and fill out DS-240, all those forms, and just come for an interview at the consulate. If you file saying that you will adjust your status, which means you will file 485 in the country on your I-140 form, then you have to file a form 824, which is to forward this approval to the consulate for the green card. That process takes like 6 to 8 months to get it approved, that 824. So answer is yes, you can still get the green card through the consulate if the priority date is correct.
Got it. So there is one more question from Ellen Reddy, Lakshmi Reddy. How to file litigation and how much it cost? My case been pending since 10/2020 and nothing happening though. I have put many requests with USCIS. My priority date is 10/2011. Please advise.
Yeah, I mean, the option to file litigation is there because for you, it's been pending for more than 6 months, right? So what I would suggest is reach out to our office, say that, you are coming through this ATA conference. What we have done is to help all these people. We have kept our rates lower. I don't want to publicize it here, but we have made it very reasonable for everyone to, so that, it helps everyone. Reach out to us on this and say specifically you're from here. I will make sure that you are taken care. And only requirement is, we specify what are the hardships that you are going through, not getting the H4EAD. What are your obligations, financial obligations you have, other family support that you have to provide for others here and back in India. We include all these hardships and file the H1. So we get an affidavit from you, which we will prepare and get it signed. And we file this before various district courts. It could be in DC, it could be in Nebraska, or wherever it is pending. So we file that. And once we file this, first we issue a summons, then US Department, the USCIS has 60 days to respond to our complaint and file an answer to that. Usually they don't do that. Before that, they just approve it. Or if they go ahead and they decide to file the answer, then there are a lot of other factors that comes to it. They'll file a motion for dismissal. We, as your attorney, will file a motion for summary judgment. So there are a lot of things that will come into that, which we rarely see. They don't fight it. So you have a higher chance of getting the EAD approved.
And also she's saying, I have sent many requests throughout Senator. They have never responded, and few times they send just generic replies saying we are behind the process and no proper answers.
I mean, that is true, but I would say if the senator is not answering to your, that's really bad. You can go to a different assemblyman or try it differently. But most of the time, because there is a huge backlog with the USCIS, the centers get the same response from USCIS. We are looking into it. There's a backlog. We are adjudicating it, and it's the same answer, and it doesn't work most of the time too. But you got to try every way.
Got it. So one more question from Shiv Puligadda. Can you please explain the eligibility criteria for interfiling from EB2 to EB1 in the same company?
EB2 to EB interfiling eligibility. The eligibility for EB1 is if you have worked in the foreign corporation. I don't know if it is from India. If you worked at least 1 year in the last 3 years, then you are eligible for an EB1 I-140. Now, that 1 year, that last 3 year can be extended if you came to the US and work for the same company. So then that 3 year will be extended. If you are working for a different employer, if you work for a different employer in between, there was a breakage of continuity of the job, then you should have worked in the last 3 years, at least 1 year. And if that is not happened, then you are not eligible for a EB1. If you are eligible for a EB1, you get it approved. There is no need to interfile. I mean, you can interfile the 485 to that. There is no porting requirement of prior date because EB1 is current as of now. So you just interfile the same thing you do, the 485J, you file it, requesting to interfile the 485 to the EB1 I-140 if it is approved or if it is pending to.
Got it. Thank you. And there is one more last question from Bhanu Ivaturi. If a minor's green card was surrendered several years ago, can she get a green card now as an adult?
Yeah, he should have the fresh eligibility. Maybe the parents are a US citizen, or if it's unmarried and the parents are a US citizen or a green card holder, there are options, but not the one that is surrendered, that is gone. You cannot revive surrendered green card in this case.
Okay, got it. And Lakshmi Reddy is asking again, I am sorry, not the senator. The USCIS is not responding to the senators for her issue, it seems.
I doubt that because that's not I've heard, because USCIS has to answer to a senator and a congressman. They have supervisory authority over these agencies. So they will answer. Maybe there is something missing piece in between. I would still suggest go to a different person. If your senator is not doing the job, write a letter to him saying that you're doing your job. You're supposed to give me a response. But what I have seen, I've never heard someone saying that USCIS does not respond. They have to respond.
Good. So, and she's saying, my kid at college is aging out, but hope his age is frozen when I downgraded to EB3 from EB2. Please advise if this is not correct, but the age freeze.
If the priority date was current, yes, the age would freeze under the final action rule. So, you have to be very careful if you are downgrading or if you are interfiling to a EB2. So talk to your attorney independently and take advice on that. So there is a lot of factors into that. It's a long discussion, but you have to be careful if you are interfiling.
Thank you so much. And yes, so that's today's webinar, friends. Hope you all had great insights regarding immigration issues. And I hope this information helped many of you. For more details, you can contact Thomas directly. Yeah, Thomas, how to contact you regarding the litigations or immigration issues? Can you tell our friends?
Yeah, go to our website. It's Thomas V. Allen, THOMAS, V as in Victor, ALLEN.com, or email at info@thomasvallen.com. On our website, and all the information is there. Call us, but always refer to ATA. We'll take good care of you guys.
Thank you. So before giving over to Anil Garu, I want to thank you, Thomas, so much for giving a lot of insights to the immigration related issues and explaining everything in detail. Thank you so much for joining us today. And it was a pleasure to have you here. Thank you.
Thank you so much. You're really awesome. Thank you.
Thank you. Thank you, Thomas. Over to Anil Garu for vote of thanks. Okay, sorry. Over to Ramakrishna Garu for vote of thanks.
Well, that was a lot of information about recent immigration rules and process. Really special thanks to Thomas Garu for coming here and giving your opinions, suggestions, thoughts. It really helps a lot of people in different ways. So also I thank you all viewers who watched this live webinar. Thank you so much for participation. Hope this helps a little bit, whatever your questions being answered. Also, I would like to thank our ATA President Bhuvanesh Bujala Garu and ATA Executive Committee for coming forward and conducting this type of webinars as and when needed based on the situation. I really appreciate their effort. Also, finally, I thank Bhargavi Garu. Within a short notice, we came and did a fantastic job in moderating this webinar. And finally, I would like to thank Anil Bodhireddy, Abr TV, for providing streaming of this live streaming, this webinar. Thank you so much. Thank you all.
తెలుగు వారినందరినీ ఒకే వేదిక మీదకు తెచ్చి తెలుగు భాషా వైభవాన్ని చాటడానికై తెలుగువారి ఉన్నతిని కోరుకొని తెలుగు భాషపై ఎనలేని గౌరవంతో గొప్ప నాయకత్వ విలువలున్న తెలుగు భాషా ప్రేమికులచే 1990లో తెలుగు తల్లి దీవెనలతో నెలకొల్పబడినదే మన అమెరికా తెలుగు అసోసియేషన్ ఆటా. అమెరికా తెలుగు సంఘం ఆనాటి నుండి ఈనాటి వరకు అనగా 31 వసంతాలుగా తెలుగు సాహిత్య, సాంస్కృతిక, విద్య, క్రీడ, ఆర్థిక, సామాజిక, ఆధ్యాత్మిక, వైద్య మరియు సాంఘిక కార్యక్రమాలను నిర్వహిస్తూ మాతృభూమికి, ప్రవాస భారతీయులకు మరియు అక్కరలో ఉన్న అమెరికా వాసులకు సేవ చేస్తూ తెలుగు జాతి మనది, నిండుగా వెలుగు జాతి మనది అని చాటుతూ విజయవంతంగా తేజరిల్లుతున్న మన ఆట ఇప్పుడు 2022 జూలై 1 నుండి 3 వరకు నేషనల్ క్యాపిటల్ వాషింగ్టన్ డీసీలో 17వ ఆటా మహాసభలను యువ సమ్మేళనంను అంగరంగ వైభవంగా జరుపుటకు సంసిద్ధంగా ఉంది. 1990 నుండి ఇప్పటి వరకు ఎందరో అధ్యక్షుల సారథ్యంలో ప్రతి ఏడాది వివిధ రంగాలలో సేవ చేస్తూ ఆటకు వన్నె తెచ్చారు. మరి మన ఆటా అధ్యక్షులు భువనేష్ బుజాలా గారి నేతృత్వంలో ఈ 7 నెలల్లో జరిగిన బృహత్తరమైన అభివృద్ధి మరియు సేవా కార్యక్రమాల విశేషాలను ఇప్పుడు తెలుసుకుందాం. ఆ రోజు జనవరి 16 టెన్నెసీ నాస్విల్లేలో ఆటాకు మరింత వైభవాన్ని తెచ్చే అపూర్వ ఘట్టం మొదలైంది. అదే ఆటా నూతన అధ్యక్షుని ప్రమాణ స్వీకారం. తరువాత నూతన బోర్డ్ ఆఫ్ ట్రస్టీస్ మరియు ఎగ్జిక్యూటివ్ కమిటీ ప్రమాణ స్వీకారం చేశారు. ఆ తదుపరి మే 8 లాస్ వెగాస్లో 2వ బోర్డు మీటింగ్ సమావేశంలో ఆటా సంస్థ చేపట్టిన అభివృద్ధి కార్యక్రమాలను, భవిష్యత్ ప్రణాళికలను చర్చించి 2022లో నిర్వహించే 17వ ఆటా మహాసభలు మరియు యువ సమ్మేళనానికి కన్వెన్షన్ అడ్హాక్ టీం, కన్వెన్షన్ కోర్ టీం, కన్వెన్షన్ అడ్వైజరీ టీంని నిర్ణయించడం జరిగింది. మార్చిలో ట్యాక్స్ ప్లానింగ్ ఫర్ బిజినెస్ అండ్ ఇండివిజువల్స్, అలానే మన ఆటా HDFsతో కలిసి మన హైదరాబాద్ మన డ్యూటీ ఫ్రీ అంటూ ఆటా సభ్యత్వం కలిగిన వారికి ఎక్స్క్లూజివ్ ఆఫర్స్తో ఎన్నో రాయితీలు కల్పించింది. అదేవిధంగా మే నెలలో ఇమిగ్రేషన్ వెబినార్, అలానే కోవిడ్ వ్యాక్సిన్ క్యాంప్ వర్జీనియా మరియు నార్త్ కెరోలినాలో నిర్వహించారు. మరియు ప్రవాస భారతీయులు మాతృదేశంలో ఎలా ఇన్వెస్ట్మెంట్ చేయాలనే అంశంపై జనవరి నుండి జులై వరకు 2 పర్యాయాలు వెబినార్లు నిర్వహించటమైనది మన ఆట. ఇంతేకాకుండా ఎంతో సేవా దృక్పథంతో ఈ 7 నెలల వ్యవధిలో నార్త్ కెరోలినా, అట్లాంటా, షికాగోలలో బ్లడ్ డ్రైవ్ను నిర్వహించడమే కాకుండా కరోనా మహమ్మారి మానవ మనుగడపై పంజా విసురుతున్న సమయంలో ఎంతో సేవాభావంతో ప్రాణాలను లెక్క చేయకుండా సేవ చేసిన మెడికల్ సెంటర్ హెల్త్ కేర్ వర్కర్స్కి, సిటీ ఆఫ్ ఫ్రిస్కో పోలీసులకు, పేదలకు, ఇల్లు లేని వారికి, ఇలా ఆపన్నహస్తం కోసం ఎదురు చూస్తున్న ఎంతో మందికి ధైర్యాన్నిస్తూ వారి ఆకలిని తీరుస్తూ డల్లాస్, అట్లాంటా, నార్త్ కెరోలినా, న్యూజెర్సీలలో ఫుడ్ డ్రైవ్ చేసి వారి మన్నలను అందుకుంది మన ఆట. భారతదేశాన ఒక పక్క కరోనా విజృంభిస్తూ ప్రజలు ప్రాణాలను గుప్పెట్లో పెట్టుకొని క్షణం క్షణం భయంతో బీతిల్లుతుంటే, మరో పక్క వైద్యానికి ప్రాణవాయువునిచ్చే సిలిండర్లు కరువవుతున్న సమయాన మన ఆట ఎంతో దాతృత్వంతో 2 తెలుగు రాష్ట్రాలకు 400 ఆక్సిజన్ కాన్సంట్రేటర్స్ను అందించి ఎందరో ప్రాణాలకు ఊపిరిపోసింది మన ఆట. గ్రామాలలో ఉన్న పాఠశాలలకు కావలసిన కనీస అవసరాలను తీర్చడానికై, పాఠశాలలను పునరుద్ధరించడానికై, విద్యార్థులకు చదువుకునేందుకు చక్కని ప్రశాంతమైన వాతావరణాన్ని కల్పించడానికై మై స్కూల్ మై రెస్పాన్సిబిలిటీ అంటూ చదువుల తల్లిని మురిపించటానికి బాధ్యతలను చేపట్టింది. అలానే సెమినార్ ఆన్ బిల్డింగ్ ఏ డ్రోన్, ఐటీ ట్రైనింగ్ ఆన్ డెవలప్స్ నిర్వహించింది. హై స్కూల్ స్టూడెంట్స్ కొరకు జూన్ నుండి ఆగస్టు వరకు శాట్ ట్రైనింగ్, విద్యార్థుల కొరకు యూత్ స్కాలర్షిప్ కార్పస్ ఫండ్ని క్రియేట్ చేసి అర్హులైన 10 మంది విద్యార్థులకు $1000 స్కాలర్షిప్గా ఇవ్వటానికి సంసిద్ధమైంది. అంతేకాకుండా చిన్నారుల కొరకు ఎక్స్క్యూ క్రియేటివిటీ వర్క్షాప్ నిర్వహిస్తుంది మన ఆట. మనిషి మానసిక ఉల్లాసానికి, ఆరోగ్యానికి బాటలు వేసేది యోగా. మరి అటువంటి యోగాపై ఆటా సభ్యత్వం ఉన్న వారికి అవగాహన కల్పిస్తూ ప్రతి ఆదివారం యోగా శిక్షణను ఇస్తుంది. అంతేకాకుండా ఆటా సభ్యులకు LA ఫిట్నెస్కి కేవలం $19.99 సింగిల్ క్లబ్ మెంబర్షిప్ని కల్పించింది మన ఆట. ఏప్రిల్ 17 ఉగాది నాడు మహాసహస్రావధాన పండితులు గరికపాటి నరసింహారావు గారితో పాటు ప్రఖ్యాత కవులతో సాహిత్య వేదిక నిర్వహించి, ఇప్పుడు భారత స్వాతంత్ర్య వజ్రోత్సవాలలో ఆగస్టు 14 నాడు మరెందరో ప్రముఖ కవులతో విశిష్ట అతిథుల నడుమ మరో సాహితీ సంబరాలను నిర్వహించబోతుంది మన ఆట. ప్రతి ఆదివారం చిన్నారులకు, యువతకి ఆటా సభ్యత్వం కలిగి ఆసక్తి ఉన్న వారికి భగవద్గీత గురించి అవగాహన కల్పిస్తూ వ్యక్తిత్వ వికాసాన్ని అందిస్తుంది ఆట. మరియు మానసిక ఉల్లాసం కొరకు క్రీడలను ప్రోత్సహిస్తూ వర్జీనియాలో వాలీబాల్ నిర్వహించింది మరియు గోల్ఫ్ టోర్నమెంట్ని ఆగస్టులో నిర్వహించబోతుంది. అలానే షికాగోలో బైకథాన్, పోర్ట్లాండ్లో యూత్ టెన్నిస్, క్రికెట్, వాలీబాల్, లేడీస్ త్రోబాల్, ఇండోర్ గేమ్స్, చెస్, క్యారమ్స్ నిర్వహించింది. అలానే వాలీబాల్ టోర్నమెంట్ను ఆగస్టు 8న పెన్సిల్వేనియాలో నిర్వహించబోతుంది. అంతేకాకుండా న్యూజెర్సీలో ఆటా సమ్మర్ ఫీస్ట్ అంటూ మహిళలకు, చిన్నారులకు మెహందీ, ఫేస్ పెయింటింగ్, ఫన్ గేమ్స్ అంటూ ఆగస్టు 1న వైభవంగా నిర్వహించబోతుంది. అలానే ఆటా సంస్థ 2 పర్యాయాలు అమెరికా భారతి అనే త్రైమాసిక పత్రికను ఏప్రిల్ మరియు జూలై 1 తేదీలలో విడుదల చేయటమే కాకుండా చిన్నారులను, యువతను ప్రోత్సహిస్తూ అమెరికా భారతి త్రైమాసిక పత్రిక ముఖ చిత్రం కొరకు చిత్రలేఖన పోటీలు నిర్వహించి ఆ పోటీలలో గెలుపొందిన సమృద్ధి గార్లాంకాకి $100 ప్రైజ్ మనీ అందించింది ఆట. అలానే మార్చిలో అటు మాతృభూమి మరియు అమెరికాలో అంతర్జాతీయ మహిళా దినోత్సవాన్ని పురస్కరించుకొని విద్య, వైద్య, రక్షణ, కళారంగాలలో ప్రముఖులైన మహిళామణులను సగౌరవంతో ఆహ్వానించి మహిళా దినోత్సవాన్ని ఘనంగా జరిపింది మన ఆట. మన ఆట ఏర్పడిన నాటి నుండి ఎన్నో వేల మంది ఆటా సభ్యత్వం స్వీకరించి ఆటా సభ్యులు అవగా ఈ ఏడాది 2000 మందికి పైగా సభ్యత్వం తీసుకొని ఆటా కుటుంబీకులయ్యారని మన ఆట సగర్వంగా తెలియజేస్తుంది. అంతేకాకుండా ఆటా అభివృద్ధికి పాటుపడుతూ బహుళ సంఖ్యలో సభ్యులను ఆటాలో చేర్చిన రీజనల్ కోఆర్డినేటర్స్ని ఈ సంవత్సరం ఆటా రీజనల్ కోఆర్డినేటర్స్ ఆఫ్ ది మంత్గా గుర్తించి అభినందిస్తుంది మన ఆట. వారిలో భాగంగా మార్చిలో ర్యాలీ నుండి హరీష్ కుందూరు గారు, ఏప్రిల్లో షికాగో నుండి ఆర్వి రెడ్డి గారు, మేలో షికాగో నుండి వెంకట్రామిరెడ్డి రవి గారు, జూన్లో వర్జీనియా నుండి రవి చల్లాగారులను ఆటా రీజనల్ కోఆర్డినేటర్స్ ఆఫ్ ది మంత్గా గుర్తించింది. వీరితో పాటు మరెందరో రీజనల్ కోఆర్డినేటర్స్ ఆటా ఉన్నతికై కృషి చేస్తున్నందుకు గాను ఆటా సంస్థ హర్షం వ్యక్తం చేస్తుంది. ఇలా ఎన్నెన్నో ఘనమైన కార్యక్రమాలు ఆటా ఎప్పటికీ నిర్వహిస్తూ తెలుగు జాతి గౌరవాన్ని శిఖరాగ్రాన నిలబెడుతూ నిత్యం తెలుగు భాషకు, తెలుగు సాంప్రదాయాలకు గౌరవాన్ని తెస్తూ భారతీయ కళా వైభవాన్ని రెట్టింపు చేస్తూ నిత్యం సేవా దృక్పథంతో ముందుకు సాగుతుందని మనవి చేసుకుంటూ ప్రేమతో సదా మీ సేవలో ఆటా.